Picture this. Your chief compliance officer receives an email at 9:14 on a Tuesday morning. The sender is the National Market Surveillance Authority. The subject line contains one word and one number, Article 50. The body of the email informs your organisation that it faces an administrative fine. The figure at the bottom of the page reads, 15 million euros. That is not a hypothetical. That is Article 99 of the EU Artificial Intelligence Act. This is Codex report. We read the regulations so you do not have to. Every claim in this episode traces directly to the official text of Regulation EU 2024-1689, the European Union's Artificial Intelligence Act, as published in the Official Journal of the European Union on July 12, 2024. Every article number, every quoted passage, every penalty figure is drawn from that text. Nothing is paraphrased from memory. Everything is on the record. Read the source. Know the rule. Today, we are reading Article 50, the transparency obligations that take effect on August 2nd, 2026. This is the article that determines what your organisation must disclose when it deploys artificial intelligence.
Here is what we will cover. The 7 paragraphs of Article 50, one by one. Who owes each obligation, provider or deployer? The penalty framework under Article 99. And a 10-step compliance checklist you can take directly to your legal team. We will also examine how Article 50 intersects with GDPR, YouTube's disclosure policy, and the extraterritorial reach of the regulation for non-EU companies.
Let us begin.
This program is educational content. It is not legal advice. For guidance specific to your organization, consult qualified EU law counsel to understand what Article 50 requires. We need to understand the problem it was designed to solve. Regulation EU 2024-1689. Formally, the regulation of the European Parliament and of the Council of June 13, 2024, laying down harmonized rules on artificial intelligence, was published in the Official Journal on July 12, 2024. It is the first comprehensive, horizontally applicable AI regulation adopted anywhere in the world. It does not regulate a single sector. It regulates the technology itself, wherever it is deployed. The Act takes a risk-based approach. It classifies AI systems into categories: unacceptable risk, which is banned outright; high risk, which requires conformity assessment and ongoing monitoring; and then a category that is, in some ways, the most practically relevant for the largest number of organizations: AI systems with specific transparency obligations. That is where Article 50 sits. It lives in Chapter 4 of the regulation, titled, and I will quote the heading exactly,
Transparency Obligations for Providers and Deployers of Certain AI Systems.
The problem Article 50 addresses is not esoteric. It is this: people are increasingly interacting with AI systems without knowing it. They are consuming content that was generated or substantially manipulated by AI without being told. Their biometric data is being processed by emotion recognition and categorisation systems without awareness. And an entirely new category of synthetic media, what the regulation terms deep fakes, is proliferating without any consistent disclosure regime. The regulation defines a deep fake precisely. Article 3, paragraph 60.
AI-generated or manipulated image, audio or video content that resembles existing persons, objects, places, entities, or events and would falsely appear to a person to be authentic or truthful.
That definition is broader than you might expect. It is not limited to face swaps of politicians. It covers any AI-generated image, audio, or video that resembles real things and would falsely appear authentic to a viewer.
Before we proceed into the article itself, two definitions are essential. The regulation draws a sharp distinction between two categories of actor, and Article 50 assigns different obligations to each.
A provider means a natural or legal person, public authority, agency, or other body that develops an AI system or a general-purpose AI model, or that has one developed and places it on the market or puts it into service under its own name or trademark, whether for payment or free of charge. A deployer means a natural or legal person, public authority, agency, or other body using an AI system under its authority, except where the AI system is used in the course of a personal non-professional activity.
In plain terms, the provider builds the AI system. The deployer uses it. OpenAI is a provider. The company that deploys ChatGPT in its customer service workflow is a deployer. This distinction runs through the entire article and determines who owes what obligation to whom. Note the personal use exception. If you are using an AI system for personal, non-professional activity, you are not a deployer under this regulation. But the moment you use it under the authority of an organization, even a small one, the deployer obligations attach.
With those definitions in hand, let us now turn to the article itself. Article 50, paragraph 1. This is the provision that requires AI systems to identify themselves to the people they interact with. Let me read it in full.
Providers shall ensure that AI systems intended to interact directly with natural persons are designed and developed in such a way that the natural persons concerned are informed that they are interacting with an AI system. Unless this is obvious from the point of view of a natural person who is reasonably well informed, observant, and circumspect, taking into account the circumstances and the context of use. This obligation shall not apply to AI systems authorized by law to detect, prevent, investigate, or prosecute criminal offenses, subject to appropriate safeguards for the rights and freedoms of third parties, unless those systems are available for the public to report a criminal offense.
Let us break this down into its operative elements.
First, who bears this obligation? The providers, not the deployers. Paragraph 1 is a design obligation. The AI system must be designed and developed in such a way that users are informed. This means the obligation sits with the entity that builds the system, not the entity that deploys it in a particular context. Second, what must be achieved? Natural persons must be informed that they are interacting with an AI system. The regulation does not prescribe the method. It does not say display a banner or play a tone. It specifies the outcome. The person must know they are interacting with AI. Third, the exception. The obligation does not apply where the AI nature of the system is obvious from the point of view of a natural person who is reasonably well-informed, observant, and circumspect, taking into account the circumstances and the context of use. This is borrowed language. The reasonably well-informed, observant, and circumspect formulation comes from established EU consumer protection law. It is an objective standard, not what any particular person would find obvious, but what a reasonable person, paying ordinary attention, would recognize. What does this mean in practice? A robotic voice responding to a phone menu is likely obvious. A chatbot on a website explicitly labeled AI assistant is likely obvious. But a sophisticated large language model deployed in a customer service chat, responding with natural language and no identification, that is not obvious, and paragraph 1 would require disclosure.
For the compliance officer, the operational question is, audit every customer-facing AI touchpoint in your organization. For each one, ask, would a reasonably well-informed, observant and circumspect natural person recognize from the circumstances and context of use that they're interacting with an AI system? If the answer is not clearly yes, paragraph 1 requires the provider to build in identification, and you, as the deployer, should be verifying that your provider has done so.
There is a subtlety here worth emphasizing. Paragraph 1 is a provider obligation. But if you are deploying an AI system that does not comply with paragraph 1, and that system interacts with natural persons in the EU, you face practical risk even though the obligation is formally on the provider. Market surveillance authorities may look at the deployment context, not just the system design. Deployers have a general obligation under Article 26 to use high-risk AI systems in accordance with instructions, and while Article 51 is not limited to high-risk systems, the principle of responsible deployment extends here through the regulation's overall compliance framework. The law enforcement exception is narrow. It applies to AI systems authorized by law, not merely used by law enforcement, but specifically authorized by legislation, to detect, prevent, investigate, or prosecute criminal offenses. Even then, appropriate safeguards for third-party rights are required. And even within that exception, if the system is available for the public to report a criminal offense, the disclosure obligation returns. This is not a loophole for general government deployment. The compliance action items from paragraph 1 are clear. Identify every AI system in your organization that interacts directly with natural persons. For each, document whether the AI nature is obvious from the context. Where it is not, confirm that the provider has built-in disclosure mechanisms. Where the provider has not, either switch to a compliant provider or implement supplementary disclosure measures at the deployment layer.
Quick note, if this breakdown is useful, hit subscribe and turn on notifications. Back to Article 50 in a moment.
Article 50, Paragraph 2, addresses something different from Paragraph 1. Where Paragraph 1 is about human-facing disclosure, making sure people know they are talking to an AI, Paragraph 2 is about technical infrastructure. It requires that AI-generated content carry a machine-readable signal that identifies it as synthetic.
Here is the text.
Providers of AI systems, including general-purpose AI systems, generating synthetic audio, image, video, or text content, shall ensure that the outputs of the AI system are marked in a machine-readable format and detectable as artificially generated or manipulated. Providers shall ensure their technical solutions are effective, interoperable, robust, and reliable as far as this is technically feasible, taking into account the specificities and limitations of various types of content, the costs of implementation, and the generally acknowledged state of the art, as may be reflected in relevant technical standards. This obligation shall not apply to the extent the AI systems perform an assistive function for standard editing or do not substantially alter the input data provided by the deployer or the semantics thereof, or where authorized by law to detect, prevent, investigate, or prosecute criminal offenses.
Let us parse the key operative terms.
Marked in a machine-readable format and detectable. This is a dual requirement. The output must carry embedded metadata, machine-readable, and that metadata must make the synthetic origin detectable. The regulation does not name a specific technical standard, but the industry consensus is converging on the Coalition for Content Provenance and Authenticity (C2PA) standard, which embeds cryptographically signed provenance manifests in media files. Effective, interoperable, robust, and reliable. 4 adjectives, each doing legal work. Effective means the marking must actually function. A watermark that is trivially stripped does not satisfy the requirement. Interoperable means it must work across systems. Proprietary marking schemes that only one vendor can read will not suffice. Robust means resistant to tampering and degradation. Reliable means consistently applied, not intermittent. But these requirements are qualified by an important phrase. As far as this is technically feasible, taking into account the specificities and limitations of various types of content, the costs of implementation, and the generally acknowledged state of the art. This is the regulation acknowledging reality. Watermarking text is fundamentally harder than watermarking images. The state of the art for audio watermarking differs from video. Providers must do what is technically feasible given current capabilities. The carve-out for assistive editing and non-substantial alteration is significant. If an AI system is performing spell check, grammar correction, color adjustment, cropping, or other standard editing functions, paragraph 2 does not apply. Similarly, if the AI does not substantially alter the input data or the semantics thereof, meaning the meaning of the content remains unchanged, the marking obligation does not attach. This is a provider obligation, not a deployer obligation. The entity that builds the generative AI system must embed the marking. But deployers have a critical related responsibility. Do not strip provenance metadata from AI-generated content. If your provider has embedded C2PA manifests, watermarks, or other machine-readable signals in the content you receive, and your post-production workflow removes them, you have undermined the marking that paragraph 2 requires. While the formal obligation is on the provider, a deployer who knowingly degrades provenance signals faces enforcement risk and, at minimum, a failure of the cooperative compliance framework the regulation envisions. The compliance action items from paragraph 2 are as follows. First, inventory all AI systems in your organization that generate synthetic audio, image, video, or text. Second, verify that each provider embeds machine-readable provenance marking in its outputs. Ask for documentation of their C2PA implementation or equivalent. Third, audit your internal workflows to confirm that post-production, compression, format conversion, and distribution pipelines preserve provenance metadata rather than stripping it. Fourth, for any provider that does not currently embed machine-readable marking, flag this as a non-compliance risk and begin evaluating alternatives or requesting a compliance roadmap. The general-purpose AI inclusion is noteworthy. The text says including general-purpose AI systems. This is the regulation reaching large language models and multimodal foundation models. If your organization deploys a general-purpose AI model that generates text or images, the provider of that model must mark the outputs, and you should be checking that they do.
If you're following along, take a second to subscribe. We publish a new deep dive every week. We move now to a provision that occupies a different space in the AI landscape. Article 50, paragraph 3 concerns emotion recognition and biometric categorisation. Technologies that, for many compliance officers, may already be on their radar because of GDPR, but which the AI Act now addresses with an additional distinct obligation.
Deployers of an emotion recognition system or a biometric categorization system shall inform the natural persons exposed thereto of the operation of the system, and shall process the personal data in accordance with regulations EU 2016-679 and EU 2018-1725 and Directive EU 2016-680 as applicable. This obligation shall not apply to AI systems used for biometric categorization and emotion recognition, which are permitted by law to detect, prevent, or investigate criminal offenses, subject to appropriate safeguards for the rights and freedoms of third parties, and in accordance with union law.
Notice immediately that this is a deployer obligation, not a provider obligation. Paragraph 1 was on providers. Paragraph 2 was on providers. Paragraph 3 shifts to deployers. If your organization deploys an emotion recognition or biometric categorization system, you are the one who must inform the persons exposed to it. Two definitions matter here. The regulation defines an emotion recognition system as
an AI system for this purpose of identifying or inferring emotions or intentions of natural persons on the basis of their biometric data,
and a biometric categorization system as
an AI system for the purpose of assigning natural persons to specific categories on the basis of their biometric data, unless it is ancillary to another commercial service and strictly necessary for objective technical reasons.
These definitions are broad. Emotion recognition covers not only facial expression analysis, but any system inferring emotions or intentions from biometric data. Voice tone analysis, gait analysis, physiological signal interpretation. Biometric categorization covers any system that sorts people into categories based on biometric data, with a carve-out only where such categorization is ancillary to another commercial service and strictly necessary for objective technical reasons. The paragraph's second operative element is the explicit cross-reference to data protection law. This is where the AI Act and GDPR formally intersect. Deployers must process personal data in accordance with GDPR, Regulation 2016-79, the EU Institutions Data Protection Regulation 2018-1025, and the Law Enforcement Data Protection Directive 2016-680. For most private sector deployers, GDPR is the operative instrument. What does this mean in practice? If your organization deploys any system that analyzes employee facial expressions in video calls, monitors customer sentiment through voice analysis, categorizes retail visitors by age group using cameras, or sorts job applicants by inferred personality traits from video interviews, you have a dual compliance obligation. Under Article 50(3), you must inform the exposed persons that the system is operating. Under GDPR, you likely need to conduct a data protection impact assessment, establish a lawful basis for processing, and implement all standard GDPR safeguards for biometric and special category data. The compliance officer's action list for paragraph 3 is this: First, conduct a thorough inventory across all departments for any system that analyzes biometric data to infer emotions, intentions, or categorize individuals. Second, for each identified system, implement notice mechanisms. Inform every exposed natural person that the system is operating. The notice must satisfy Article 50(5), which we will discuss shortly. Clear, distinguishable, at the time of first exposure. Third, ensure GDPR compliance is in place, lawful basis, DPIA where required, data subject rights, minimization, storage limitation. Fourth, document the intersection, maintain a register that maps each emotion, recognition or biometric categorization deployment to both its AI Act obligations and its GDPR compliance measures.
This paragraph will affect sectors disproportionately. Retail, human resources, call centres and security services are the most exposed. If your organisation operates in any of these sectors, paragraph 3 compliance should be treated as a priority. Quick reminder, subscribe and ring the bell so the next episode lands in your feed automatically.
Paragraph 4 of Article 50 is, for many organisations, the provision with the widest practical reach. It addresses two distinct categories of content: deepfakes and AI-generated text published to inform the public.
First, deepfakes.
Deployers of an AI system that generates or manipulates image, audio, or video content constituting a deepfake shall disclose that the content has been artificially generated or manipulated.
Then AI-generated text.
Deployers of an AI system that generates or manipulates text, which is published with the purpose of informing the public on matters of public interest, shall disclose that the text has been artificially generated or manipulated.
Both are deployer obligations, and both come with significant carve-outs that will shape how this provision operates in practice.
This obligation shall not apply where the use is authorized by law to detect, prevent, investigate, or prosecute criminal offense. Where the content forms part of an evidently artistic, creative, satirical, fictional, or analogous work or program, the transparency obligations set out in this paragraph are limited to disclosure of the existence of such generated or manipulated content in an appropriate manner that does not hamper the display or enjoyment of the work. This obligation shall not apply where the AI-generated content has undergone a process of human review or editorial control, and where a natural or legal person holds editorial responsibility for the publication of the content.
Let us work through the implications.
The deepfake disclosure obligation is straightforward in principle. If your organization uses AI to generate or manipulate image, audio, or video that constitutes a deepfake, recall the definition: content resembling real persons, objects, places, or events that would falsely appear authentic. You must disclose this. The artistic carve-out does not remove the obligation. It moderates it. For artistic, creative, satirical, or fictional work, you still must disclose the existence of the synthetic content, but you may do so in a way that does not hamper the enjoyment of the work. A small credit at the end of a film, a note in a video description, a label in the metadata. These are the kind of measures the carve-out envisions. The obligation remains, only the manner is relaxed. The AI-generated text provision will have profound effects on media, marketing, and content production. If your organization publishes AI-generated text on matters of public interest, news articles, policy analyses, market reports, public health information, you must disclose the AI involvement. The phrase matters of public interest is broad and will be subject to interpretation, but it clearly encompasses journalism, regulatory commentary, health information, financial reporting, and political content. The editorial review carve-out is the most practically significant exception in the entire article for businesses. If the AI-generated content has undergone a process of human review or editorial control, and a natural or legal person holds editorial responsibility for the publication, the text disclosure obligation does not apply. This means an organization that uses AI to draft content, but subjects that draft to genuine human editorial review and publishes under named editorial responsibility, may not need to disclose the AI involvement in the text.
But a word of caution, this carve-out requires both elements, human review and editorial responsibility. Perfunctory review will not suffice. The regulation says a process of human review or editorial control, implying a substantive engagement with the content. And editorial responsibility must be held by an identified natural or legal person, not a faceless automated system.
For the compliance officer, the action items from paragraph 4 are these. First, identify all uses of AI-generated or AI-manipulated media across your organization, marketing campaigns, product imagery, promotional video, corporate communications. Second, for any content constituting a deep fake, implement disclosure mechanisms. Third, for AI-generated text on matters of public interest, implement disclosure unless the editorial review carve-out clearly applies. Fourth, if relying on the editorial review exemption, document the review process, who reviewed, when, what changes were made, and who holds editorial responsibility. That documentation is your evidence of compliance if challenged.
We have now walked through the 4 substantive obligations: interaction disclosure, machine-readable marking, emotion recognition and biometric categorisation notification, and deep fake and AI-generated text disclosure. Paragraphs 5, 6 and 7 of Article 50 address how these obligations must be performed and what comes next in terms of implementation guidance.
The information referred to in paragraphs 1 to 4 shall be provided to the natural persons concerned in a clear and distinguishable manner at the latest, at the time of the first interaction or exposure. The information shall conform to the applicable accessibility requirements. Paragraphs 1 to 4 shall not affect the requirements and obligations set out in Chapter 3, and shall be without prejudice to other transparency obligations laid down in union or national law for deployers of AI systems. The AI Office shall encourage and facilitate the drawing up of codes of practice at union level to facilitate the effective implementation of the obligations regarding the detection and labeling of artificially generated or manipulated content. The Commission may adopt implementing acts to approve those codes of practice in accordance with the procedure laid down in Article 56(6). If it deems the code is not adequate, the Commission may adopt an implementing act specifying common rules for the implementation of those obligations in accordance with the examination procedure laid down in Article 98(2).
Paragraph 5 establishes 2 cross-cutting requirements that apply to all 4 substantive paragraphs. First, clear and distinguishable. The disclosure must not be buried in terms of service, hidden in a footer, or obscured by design. It must be presented in a manner that a natural person will actually notice and understand. This is a presentation standard, and it has real design implications. A tiny font disclaimer at the bottom of a web page does not meet this standard. An inline notification prominently placed in language the user reads that approaches it. Second, at the latest at the time of the first interaction or exposure. This is a timing requirement. The person must be informed before or at the moment they first interact with or are exposed to the AI system or AI-generated content. Not after, not in a follow-up email, not in a monthly report. At the time of first exposure. For different channels, first exposure means different things. For a chatbot, the first message. For a voice assistant, the first utterance. For AI-generated content on a website, when the page loads. For AI-generated video, when the viewer begins watching. For email containing AI-generated text, when the email is opened. The accessibility requirement means disclosure must conform to applicable accessibility standards, web content accessibility, guidelines for digital content, relevant national accessibility legislation for other contexts. Disclosure that is only visual fails for visually impaired users. Disclosure that is only auditory fails for hearing impaired users. Paragraph 6 is a non-derogation clause. It clarifies that Article 50's obligations exist in addition to, not instead of, the obligations in Chapter 3, which covers high-risk AI systems and any other transparency obligations in EU or national law. If your AI system is classified as high risk under Chapter 3 and also triggers Article 50 obligations, you must comply with both. One does not substitute for the other. Paragraph 7 looks forward to implementation. The AI Office, the EU body established under the regulation to oversee AI governance, is tasked with facilitating codes of practice for the detection and labeling of AI-generated content. These codes of practice will provide practical guidance on how to implement the marking and labeling obligations of paragraphs 2 and 4. Importantly, the Commission retains the power to adopt implementing acts, binding legal measures, if voluntary codes of practice prove inadequate. This means the compliance landscape for Article 50 will continue to evolve. The AI Office will develop codes of practice. The Commission may adopt implementing acts, and the practical standards for what constitutes effective marking or clear and distinguishable disclosure will be refined over time. The compliance officer's obligation is to monitor these developments actively. A compliance program built today may need updating when codes of practice or implementing acts are finalized.
The action items. Design your disclosure mechanisms to meet the clear and distinguishable standard now. Implement them to fire at first exposure, not later. Ensure accessibility compliance, and establish a monitoring process for AI Office codes of practice and Commission implementing acts. If you want more episodes like this on EU regulation, subscribe. It's the single thing that helps us most. We have now read every operative paragraph of Article 50. You know what the obligations are, who bears them, and how they must be performed. The question a compliance officer must answer next is, what happens if we do not comply?
Article 99 of the regulation sets out the penalty framework. Let me be precise about which tier applies to Article 50.
Non-compliance with any of the following provisions related to operators or notified bodies, other than those laid down in Articles 5, shall be subject to administrative fines of up to EUR 15,000 pound, or, if the offender is an undertaking, up to 3% of its total worldwide annual turnover for the preceding financial year, whichever is higher. Transparency obligations for providers and deployers pursuant to Article 50.
This places Article 50 non-compliance in the second of 3 penalty tiers. For context, the highest tier, Article 99(3), applies to violations of the prohibited AI practices in Article 5, fines up to €35 million or 7% of worldwide turnover. The lowest tier, Article 99(5), applies to supplying incorrect information to authorities, fines up to €7,500,000 or 1% of turnover. Article 50 sits in the middle tier, €15 million or 3% of global turnover. For a company with €2 billion in annual revenue, 3% is €60 million. The whichever is higher formulation means the percentage figure will dominate for large enterprises. There is a specific provision for SMEs. Article 99, paragraph 6.
In the case of SMEs, including startups, each fine referred to in this article shall be up to the percentages or amount referred to in paragraphs 3, 4, and 4, whichever thereof is lower.
For SMEs, the calculation inverts. It is the lower of the 2 figures, not the higher. This is an explicit recognition that the percentage figure might be negligible for a small company, while the fixed amount would be existential. For an SME with €1 million in turnover, 3% is €30,000. 15 million would be a death sentence. The regulation gives them the 30,000 figure. Article 99, paragraph 7, provides 10 factors that authorities must consider when determining whether to impose a fine and at what level. These include the nature, gravity, and duration of the infringement, the number of affected persons, whether the operator cooperated with authorities, the degree of responsibility taking into account technical and organizational measures implemented, whether the operator self-reported the infringement, and any action taken to mitigate harm. The enforcement mechanism operates through national market surveillance authorities and national competent authorities, with the AI Office providing coordination at the union level. Member states are required to lay down rules on penalties without delay and at the latest by the date of entry into application, by August 2, 2026.
For the compliance officer, 3 practical points about this penalty framework.
First, the penalties are not automatic. Authorities have discretion, but that discretion is guided by factors that reward proactive compliance. Self-reporting, cooperation, implemented technical measures, mitigation of harm, a documented compliance program is your strongest position. Second, the provider-deployer distinction matters for penalty exposure. If the non-compliance relates to a provider obligation, paragraphs 1 or 2, the provider faces the fine. If it relates to a deployer obligation, paragraphs 3 or 4, the deployer faces it. But in practice, regulators will likely examine the full chain. Third, the penalty framework under Chapter 12 has applied since August 2, 2025. The penalties are live. What arrives on August 2, 2026 is the general application date for the substantive Article 50 obligations themselves. After that date, the penalty framework and the transparency obligations are both fully operative. Article 50 does not exist in isolation. It intersects with other regulatory frameworks, both within and beyond the EU. and the compliance officer who treats it as a standalone obligation will miss critical dependencies. The most explicit intersection is with GDPR. Article 50, paragraph 3, directly references three data protection instruments: Regulation 2016-679, the General Data Protection Regulation, Regulation 2018-1725, which governs data protection for EU institutions, and Directive 2016-680, the Law Enforcement Data Protection Directive. This means that any deployment of emotion recognition or biometric categorisation triggers a dual compliance requirement. The notification obligation under Article 53 and the full weight of GDPR's data protection requirements apply simultaneously. In practical terms, you need a lawful basis for processing biometric data under GDPR Article 9, Special Categories of Data, a data protection impact assessment under GDPR Article 35, transparent privacy notices under GDPR Articles 13 and 14, and the Article 53, notification to exposed persons. These are not alternative routes to compliance. They are cumulative. For organizations distributing content on YouTube, there is a distinct but related compliance pathway. YouTube's own AI disclosure policy requires creators to declare when a video contains altered or synthetic content that looks realistic. The platform then applies a label to the video. YouTube's toggle mechanism provides one practical means of satisfying Article 54's deep fake disclosure obligation for video content served to EU viewers. When you enable the altered or synthetic content option in YouTube Studio, the platform attaches a disclosure label, visible in the description, and, for sensitive topics, prominently on the video player itself. This satisfies the clear and distinguishable requirement of Article 55 for YouTube distributed content.
But YouTube's policy has limits as a compliance mechanism. It addresses YouTube-hosted content only. If your organization distributes video through other channels, your own website, social media platforms, email direct embedding, you must implement equivalent disclosure mechanisms on each distribution channel independently. YouTube compliance is not global compliance. Article 50 follows the content to the viewer, regardless of the platform.
For organizations based outside the European Union, the extraterritorial reach of the AI Act is critical. The regulation applies to providers placing AI systems on the market or putting them into service in the Union, and to deployers that are located within the Union. But it also applies to providers and deployers located in a third country, where the output produced by the AI system is used in the Union. This means a US company that deploys an AI chatbot serving EU customers is a deployer subject to Article 50, Chol 1. A UK company that uses AI to generate marketing content distributed to EU audiences is subject to Article 50. Or a Japanese firm deploying emotion recognition in a service accessed by EU natural persons is subject to Article 53. The physical location of the company is irrelevant. What matters is where the AI system's output reaches natural persons. For UK-based organisations specifically, post-Brexit, the UK is developing its own AI regulatory framework, which takes a different approach from the EU, principles-based rather than the EU's prescriptive risk-based classification. But for any UK organisation serving EU markets, the EU AI Act applies in full. Compliance with a future UK AI framework does not substitute for compliance with the EU AI Act for EU-facing operations.
The compliance officer's action items for cross-jurisdictional exposure. First, map every Article 50 obligation against your existing GDPR compliance programme. Identify overlaps and gaps. Second, for each content distribution channel, verify that the Article 50 disclosure mechanism is implemented at the platform level. Do not assume that YouTube compliance covers all channels. Third, if your organisation is based outside the EU but serves EU natural persons, treat the AI Act as applying to you and build compliance accordingly. Fourth, monitor the UK's AI regulatory development, but do not rely on it as a substitute for EU compliance. One more reminder, subscribe before the checklist if you haven't already. Final stretch coming up. We have read Article 50 in the regulation's own words. Every obligation, every carve-out, every enforcement consequence. Let me now consolidate the compliance actions into a single checklist. 10 steps, one for each obligation we have discussed.
1. Audit all customer-facing AI systems for Article 50, Paragraph 1, Interaction Disclosure. For each system, document whether the AI nature is obvious to a reasonably well-informed, observant, and circumspect person. Where it is not, confirm that the provider has built-in disclosure mechanisms. 2. Verify that every AI provider your organization uses embeds machine-readable marking in synthetic outputs per Article 50, Paragraph 2. Request documentation of their C2PA or equivalent implementation. 3. Do not strip provenance metadata from AI-generated content. Audit post-production, compression, and distribution workflows to confirm metadata preservation. 4. Identify all emotion recognition and biometric categorisation deployments across your organization. This includes facial expression analysis, voice sentiment, gait analysis, and biometric sorting. 5. Implement disclosure for all synthetic media constituting deep fakes per Article 50, Paragraph 4. For artistic or creative content, disclosure may be moderated in manner but cannot be omitted. 6. For AI-generated text on matters of public interest, implement disclosure unless the editorial review exemption clearly and documentably applies. 7. Design first exposure disclosure mechanisms per Article 50, Paragraph 5. Disclosure must be clear, distinguishable, and timed no later than the first interaction or exposure. 8. Conduct a GDPR data protection impact assessment wherever Article 50, Paragraph 3 intersects with personal data processing, particularly for emotion recognition and biometric categorisation. 9. Document all compliance measures for market surveillance readiness. Your compliance program is your strongest evidence under the Article 99 mitigating factors. 10. Monitor the AI Office's development of codes of practice under Article 50, Paragraph 7. The compliance landscape will continue to evolve. Your program must evolve with it.
This was Codex Report. Every episode you just watched was produced entirely by artificial intelligence. The script, the narration, the visuals, the fact-checking pipeline. We use the most capable AI models available today. But AI makes mistakes. And if you caught anything I got wrong, please leave a comment. Your feedback is how we train better episodes. Comments also help us reach the YouTube algorithm. That's how we earn the resources to keep producing free, deeply researched content like this. So if this saved you time, subscribe, turn on notifications, and leave a comment with what you'd like us to break down next. See you on the next Codex report.